I'm joined now by All Rise News' Adam Klasfeld. Adam, you and I have been focusing very heavily on this order that was blocking Donald Trump in Oregon from being able to deploy the National Guard. That issue is obviously appealed up to the Ninth Circuit. This is a very important case that really is going to determine whether or not Donald Trump has the ability to deploy these troops, not just in Oregon, but in other cities as well. The Ninth Circuit has now issued a decision here. Can you explain what just happened in court?
What happened was the Ninth Circuit issued a stay of the lower court's order. Now, I know that sounds bad. It sounds like the three-judge panel has overturned the judge's order. But what just happened was very limited. What they issued was a stay that allows the Trump administration to federalize the National Guard, but not deploy it. So the long story short, to the answer to your question, Brian, is nothing changed on the facts on the ground. Trump still cannot deploy the troops to Portland for the purpose of guarding federal buildings, protecting federal personnel. This is the Ninth Circuit saying, we want to take our time in this ruling and preserve the status quo. The status quo, when we got this case before Judge Immergott's ruling, was the issuance of an order federalizing the Oregon National Guard. They can federalize the Guard, they can federalize the California National Guard, but they cannot deploy it. So it's a very limited ruling, and they went out of the way to say this does not influence or impact in any way what our decision on the merits will be.
And that's the point I want to dig in on here, because normally when you have an appeals court that is going to stay or even overturn a lower court's ruling, that would signal a likelihood that when they do hear this case on the merits, that it's going to be overturned. And so are you saying here that the court is basically assuring us that in no way does their decision to stay this case signal that when they do hear this case on the merits, which I guess is imminent, that they're more likely than not to actually overturn the trial court's ruling?
That's exactly right. They are going out of the way to say that there is no indication in their ruling how they will rule in the future. As a matter of fact, I have the ruling in front of me, highlighted the passage in question where they explicitly say just that. So if you hear the Trump administration saying this is a great victory and the appellate courts set lower courts straight, read them this line. Given its limited nature, an administrative stay, quote, does not constitute in any way a decision as to the merits for the motion for a stay pending appeal. So they went out of the way to say we are not saying anything about the merits, which they are going to hear in oral arguments on Thursday. They set a very quick schedule. They have allowed friends of the court briefs to be submitted. They said that they issued this order so they can take their time, consider the case, preserve the status quo. So I wouldn't read too much into this ruling, other than, of course, it is at least in part a ruling that the Trump DOJ wanted, but it's also falls far short of what they wanted, because what they wanted to do was to deploy the troops.
So now we're basically in a holding pattern where we do preserve the status quo, although I would have loved to see the Ninth Circuit Court of Appeals simply say, no, we agree with the trial court. You don't have the ability to deploy the National Guard. That's it. End of story. But in this situation, now that there was a stay, that obviously sends everybody looking toward the actual case on the merits. And so when can we expect a ruling on the merits on this issue?
It's tough to say the ruling, but I can say that the oral arguments are happening tomorrow as we
Okay.
speak today. So it's happening on Thursday morning on at I believe 9 a.m. Pacific time. So would be noon where I am. And so this is coming to a reckoning, at least perhaps we'll see during oral arguments, are where the judge is leaning. It was very clear the last time there was a three-judge panel in the Ninth Circuit discussing an issue like this in the California case, where they were leaning. We'll see if it's the same here, or whether their questions are a little bit more down the middle.
Now, Adam, while you're reading the judge's ruling in this case, I had mentioned before that obviously, I would have liked to see them just agree with the lower court. Do you agree with this ruling? Does it kind of make sense on its face that the judges would opt to stay this decision, while also offering up the caveat that doesn't impact whatsoever one way or the other how they're going to rule on this thing?
It's a pretty strange ruling, Brian. On the one hand, I thought that Judge Immergut had issued a very powerful ruling that is showing exactly why there was absolutely no reason to deploy the National Guard. That there was no reason, that the facts on the ground, that Trump's claims about what was going on was untethered to the facts.
Right.
That we have inflatable frogs and
Yeah.
capybaras standing in
Right.
front of an ice
Well,
facility, and that
so
doesn't require the National Guard. I think that this is a panel that Trump, frankly, got a favorable draw. It's a three-judge panel. Two of them are Trump appointees. Then again, the ruling that's under appeal is from a Trump appointee. I'll say one of the Trump appointees on this panel is someone who ruled in favor of California Governor Gavin Newsom in a COVID-19 restriction case. So I wouldn't read too much into the composition of that either. It's just quite possible that they are trying to play this cautious, some might say overly cautious. But what they have done in cumulative effect doesn't change anything on the ground.
I should also note for those who are watching right now that as far as the Ninth Circuit is concerned, there are 29 judges. 16 of them were appointed by Democrats and 13 were appointed by Republicans. So Trump had a great draw here by pulling two judges on this three-judge panel who he himself appointed, along with one judge who I believe a Democratic president appointed. You correct me if I'm wrong. Is that right,
Yeah,
Adam?
that is correct.
So even in an event where a three-judge panel ultimately ruled in favor of Trump, it is still possible that the plaintiffs here can ask for en banc review and get the entire bench to sit down and hear this case. And Democrat nominated judges certainly have an advantage over Republican nominated judges on the Ninth Circuit Court of Appeals. So just something to keep in mind as we look deeper into this process. But Adam, what I wanted to know is, you had just mentioned that Judge Immergut, at the trial court in Oregon, had ruled that Trump's pretext to be able to send in the troops was untethered to reality. There are three conditions that you and I have spoken about at length that any of which need to be hit in order to justify a domestic troop employment. There needs to be a foreign invasion, there needs to be a rebellion or insurrection, and there needs to be an inability of the local government to be able to effectuate federal law. None of those thresholds were met. None of those conditions were met here. And so where does this Ninth Circuit panel get off in saying that they just have to stay Judge Immergut's ruling when clearly there is no foreign invasion, clearly there is no rebellion? I mean, we're looking at protests of like 8 people, half of whom are dressed up as frogs and bears outside of these ICE facilities in Portland, and clearly there's no inability for the local government in Portland to be able to effectuate its laws. And so why not just come out and say, we agree with the lower court ruling, this Trump-appointed judge who said that his pretext to be able to send in the troops was untethered to reality?
Right. I mean, I think a lot of people in Portland right now wish the court did just that. This is the same Ninth Circuit under those three prongs that you mentioned, Brian, that had said that the conditions on the ground in Los Angeles were they didn't comment on the rebellion prong or the invasion prong, but they found in favor of the Trump administration on the prong of the regular forces. They had found under this highly deferential standard that the regular forces couldn't control what was going on in Los Angeles, which is ridiculous. So this is the Ninth Circuit. That's a type of deference that they are applying. I will say, Karen Immergut, the federal judge who ruled against the Trump administration, said even under that standard, this is so untethered to the facts. And she went farther than that. This is, again, we've mentioned time and again, a Trump appointee. She went farther than that. She quoted James Madison, who, when during the signing of the U.S. Constitution, warned that the use of the military for civilian purposes could become tools of tyranny. That was a quote that led off her ruling. She warned that this sort of use of the military could be a threat to rule of law itself, and said this is a nation of civilian law, not martial law. That is a Trump appointee, Judge Immergott, warning about the stakes of this case. It would have been nice to hear the Ninth Circuit Court of Appeals ratify that from the get-go. What we got here is a ruling that maintains the status quo. Who knows? Maybe we will hear full-throated support of those principles. Maybe not. Maybe there'll be a dissent in there. We'll see on what side. But I would encourage people not to read too much into this decision, because as I read this 4-page ruling, they're not tipping their hand, and we're going to find out soon whether they reinforce Judge Immergott's very powerful opinion on this.
I would assume, given the pressing nature of this issue, that even as they're hearing oral arguments tomorrow on this, that we'll actually get some type of ruling either way. Because if it is as pressing as the Trump administration claims, so pressing to warrant the federal guard, which he's federalized to be deployed into Portland, clearly there is some urgent nature to this question, and so they're not going to sit on it for a month here in
Right.
waiting to rule. Is that correct?
I think that they're going to rule quickly for the very reason that you said. And the fact that we are having oral arguments tomorrow, Thursday, that is a very fast schedule that suggests that they are willing to act very quickly. I doubt, just from my having covered appellate arguments many, many times, they're not going to rule from the bench. They are going to go back and craft whatever opinions that they're writing. It might take a couple of days, but as you said, I highly doubt that it will take a number of weeks or months. They have moved this thing along very quickly. And I think that the way I interpret this ruling is a safeguard to give them wiggle room. That if the Trump administration were to complain, hey, you're holding us up. No, we're not. We're just preserving the status quo here. So this might just be this sort of security that they put out to keep a holding pattern, if necessary, to write their opinion.
All right. Well, we will, of course, stay on top of this issue as we await some decision one way or the other in the coming, hopefully, days here. For those who are watching, if you are not yet subscribed to Adam's newsletter, it is called All Rise News. It's an excellent resource, and he is an independent journalist, so he relies on individual folks like you supporting his work. When you donate to All Rise News, it's not going to some multinational media conglomerate. It is going to him supporting his work. He travels all over the country on his own dime to make sure that he is there for these arraignments, for these hearings, wherever they may be, whether it's Kilmar Abrego Garcia's trial in Tennessee, whether it's in New York or D.C., anywhere in the country. So it goes a long way. So I'm going to put the link to All Rise News right here on the screen and also in the post description of this video. I'll also put the link to my channel on this screen. If you are not yet subscribed to both, please do us a favor and subscribe to both. Thanks so much, Adam, for taking the time.
Thank you so much, Brian, for having me. Always a pleasure.